and ask your question or tell us what you think should be done. Who is at fault here, right? Yeah. So please, if you have, just in case you're joining us and you didn't hear the story, the whole story is that there's the lady that was working in a hotel, and then there's this rich man's room she was cleaning, and then she got to find out that the man disposed the sperm, and she took it and inserted it into her body and got pregnant for the man, knowing fully well that the man is wealthy enough to take care of the child. Then afterwards, I think 2 years later or so,
3 years later.
3 years later, she came back to sue the man. So at this point, I don't know who is at fault, so feel free to call us in and tell us your own view on this particular case, all right, as the program is going on. So now let's move into the operative parts of the Child's Right Act.
Yeah. First, before we even go into the operative parts of the Child Rights Act, let us talk about who is a child.
Who is a child?
Who is a child?
Okay.
It's very important so that we know the group of people we are talking about.
We are dealing with. Okay.
Now, a child is a person between the age of 0 and 18 years. And now, a child again is a dwelling capax. When we say someone is a dwelling capax, we are saying that the person does not have capacity, capacity to negotiate, to go into a contract for necessaries, except for necessaries. He cannot go into a contract. He cannot sue and be sued.
Okay.
If you want to sue him, you sue by next friend, and he defends by guardian ad litem. He is entitled to child support.
Okay.
That is, he cannot run away from child support.
Yeah.
At all times, he is dependent on an adult for his livelihood. You understand?
Yeah.
Either that adult is by adoption, which we had already discussed, or is by fostering, or is by wardship, or is by the parents, or by one of the parents, or by a guardian. The issue is that that person between the age of 0 and 18 is dependent on another person. That is why most universities, they don't agree to admit a child that is between 16 and 17. In fact, the law has been passed in Nigeria now that if you are not 17, is it 17 or 18, the universities will not admit you, because the presumption is that a child cannot go into a tertiary training. You understand? Because university, polytechnic training, colleges of education, they are tertiary in nature. They are not like the primary and the secondary. So the law expects a child to have finished nursery, from nursery to secondary, written the WAEC at the age of 18 or 17, and be ready to get into the university at 18. So if you go on and on, you find out that a child is that person between the age of 0 and 18 who is dependent on another for his survival.
Person. Yeah. Okay.
Yes.
All right. Thank you very much. So now we move into the operative parts of the child's right.
Sorry, let me add something
Let
concerning the age of a child between the ages of 0 to 18 years. That one is applicable to Nigeria. When you talk of the common law, it is from 0 to 21 years.
Okay.
So that's where they now start counting their adulthood from.
Oh,
so that's
0
just
to
what I want to
21.
add. Yes.
Okay. All right. So now, I don't know. It seems the operative part of the Child's Right Act.
Yeah, Section 1.
Okay.
Section 1 of the Child Rights Act.
Okay.
Is that every decision you take when it concerns a child, that the interest of the child is of paramount importance. That is by Section 1.
Okay.
So every individual, every public or private bodies, all institutions, all services, all courts of law, all administrative or legislative bodies, the most important person, the child is, the interest of that child is paramount. Okay. Not the interest of the father, not the interest of the mother, not the interest of the guardian.
That links us to that case. Because that case, they consider the interest of the child.
Yes, of that case now, that's a very case that the woman sued for the sperm. The court consider the best interest of the child, which is that the child is entitled to child support since he's a child. Then by Section 2 of the Child Rights Act, we are talking about that the child is entitled to protection and care necessary for his or her well-being by individuals, by government and other authorities as it relates to the safety, health, fundamental rights, welfare and competent supervision of the child. That is what Section 2 talks about. Now, if you go down, you will see from section 3 to 20 is talking about the fundamental rights of the child. These fundamental rights are equivalent to what is reproduced in section 36. I mean, in chapter 4, sorry. What is reproduced in chapter 4 of the 1999 Constitution. That is what is reproduced in section 3 to section 20 of the Child Rights Act. That is, we're talking about child right to life, right to dignity of the human person, right to fair hearing, right to education, right to freedom from discrimination, right to fair hearing, like we have rightly pointed out. So those are some of the rights. Right to private and family life. So those things are listed like that, as they are listed in the Constitution. They are so listed in the Child Rights Act. Now, if we go down, another point of importance is the adoption, which we discussed earlier in this. We talk about adoption, that a child can actually be adopted, and then we stated the grounds, the requirements for a person for a person to adopt a child, which we said that that person has to be at least the age of 25. If the person is married, that the both of them must give consent to the adoption, that they should be mentally fit, financially fit, financially and mentally fit to take care of that child. They should be staying in the same state with the child, as in what the law allows you to adopt a child and take him out of Akwa Ibom State and into Cross River State, or adopt a child and take him out of Cross River State to Lagos State. If that child must ever leave Cross River State where he was adopted, it should be at the age of majority. That is from the age of 19. So where you adopted the child, that's where the child stays. Until it gets to that age.
So sorry to cut you. If you're not maybe staying in this particular country here, and you just wanted to, maybe for example, you're staying in UK, and then you come down to Nigeria, you want to adopt a Nigerian child. So it's a must that you have to stay in Nigeria for the number of those years before you take the child
Before you
back.
can take the child out, yes.
Really?
Yes.
Oh,
in
wow.
fact, one of us have a problem already in UK. I'm sure you've heard the story. Let's not even mention the name. When we're talking about organ harvesting and all that. If it was in Nigeria, there would have been no problem. In fact, it would not have even been a criminal offense. You understand? So if you are adopting a child, the law is very clear. It says if you're adopting a child, you don't take that child out of the state where you adopted.
Really?
Yes, you don't.
Wow.
You keep the child with you. When the child is of age of majority, that he now voluntarily, by the time he say let's go to Lagos, he is ready and packing his bag at the age of 19. That is when you can take him out of that state. You don't.
What about vacations?
You know vacationings.
Wow.
Yeah. The child has to say, but then the law is not an ass. If you must take that child, then you have to go back to the area, to the body, to the institution where the child was adopted, and apply to take the child on vacation. And then state the number of days or weeks or months you stay in vacation, and then state when he's coming back. So during the holiday, for instance, like we are going to have the long holiday from July to September, you could actually apply that the child is coming with you to UK. It's possible. Once it's granted by the court, you can take it. Because when you get to the airport, yes, when you get to the airport, once they have discovered that from the documents the child is an adopted child, the next thing is they will want to see the leave of the court for you to take the child out on that vacation. And it is only when you present that leave that child can go out. Otherwise, the child will be sent back. You can go for your vacation. The child will be sent back, yes, to the house. Because by the law of adoption, you cannot take him out of the state where you adopted him.
Oh, wow. Okay.
Yes.
All right. Nice.
So now there is another one. Maybe I don't know whether to allow my colleague to talk. I've been doing all the talking.
Okay.
When we get to Will, I will talk.
Okay. Then we have what we call fostering.
Okay.
Fostering. That adoption, like I said, is under Section 125 of the Child Rights Act, Section 125. Then we have what we call fostering. Fostering under Section 100 of the Child Rights Act. And then children that can be fostered are the following. They are abandoned children, they are orphans, they are deserted children, voluntarily presented children by either himself or by relatives. Maybe the father and the mother are dead. He himself now walks up and says he wants to be fostered. And I'm going to shock you with an example. Abused, neglected and ill-treated children can be fostered. Children with parents who do not or cannot exercise proper guidance. You know, there are some parents that are not mature enough to even take care of their children. Some of them are living in the brothels. I'm not saying that living in a brothel is bad. It's only God that can judge. Some of them are drunkards. Some of them are into, what do you call it, smoking. They are into smoking, drug abuse and all that. So they don't have the mental capacity to take care of
some
it.
in prison.
Some in prison. Thank you. So they don't have the mental capacity to take care of those children. So they can be fostered. Then there are destitutes. Then there are children that are wandering the streets. What we call a foundling. Okay. You know, a foundling. They are wandering. Then children voluntarily presented by parents for fostering. Okay. And like I was trying to tell you, a good example of a foster home is the Redeem Home. That is the real name of that place. It is a foster home where groups of children under that definition is taken care of by a mighty being. Yes, who only has love for people of that nature. So the Redeem Home is one of them. Now, qualification for fostering is under Section 104 of the Child Rights Act. That the applicants are not less than 25 years of age. That is the person that wants to create the foster home. It is either an applicant that have the means or the government. The state government also have the right to build a foster home and bring in such children. Then the applicant and the child are resident in the same state. The same issue repeats. They have to be resident in the same state. The applicant and the children. Now the applicant is a citizen of Nigeria, and that the applicant has the means of maintaining the children or the child. That the applicant is a person of unquestionable integrity. Very important. And that because most of these children come in, at the end of the day, they are found in the hands of a ritualist. So he must be a person of unquestionable integrity. He must produce a certificate of physical and mental fitness. And the applicant and the child, in most cases, must be of the same sex. Because some of them will come, they say they want to foster. You find out that if you go to Imo State, so many times the police will go in, break in a house and find out that all the women there are pregnant. The owner of the home will bring a man to impregnate the children, the girls, and then the girls will give birth to children, and they now sell. They now go into the trade, slave trade, selling of those babies. So those are the conditions that a person must meet in order for him or her to be granted the license to open up a foster home. Yes.
All right. Thank you very much. That was really elaborating. Yes. Very interesting, honestly. Please, if you're just joining us, this is Regnum Continuous Legal Education. And if you have a question to ask, pay attention to the discussion of today. Our phone lines are open. Feel free to call us in for any question of any kind. And as well, you can join us through our YouTube as well to drop your comments or you drop your question, whichever question you would like the legal practitioners to, address while the program is going on. Yes, we'll move straight to the next chapter, which is on my categories here.
No, I still have more to add.
Under
the operative part. Yes, we have the guardian. We have the guardian ad litem.
Oh, really?
A guardian ad litem is a person that takes the heat for the child.
Okay.
Some parents, it normally happens that, in fact, when we are going down, we'll discuss it, but let me bring it since it comes under the child, for the children, for the cases of the children. Now, I find out that somebody is working in 34 Ambo, or the person is working in agricultural and science park, or that is a government establishment, or working at the Federal Ministry of Health, or working at Federal Ministry of Justice. And then at the end of the day, he was given a form on the day. On the day he resumed duties, he was given a form to fill. And then in that form, they wrote, who is your next of kin? And then he actually filled somebody. Said, this is the next of kin. Now, it is the guardian ad litem that has the power and authority to relate with respect to the benefits of that man in the event of death. In the event of death of the maker. That in itself, that next of kin itself is a form of a will. When we get to a will, we'll mention it. It's a form of a will.
Okay.
It's a kind of an ambulatory, what we call an ambulatory will.
Okay, what does ambulatory
Ambulatory means you can change it. For instance, if you had only that child, and you put his name as next of kin, for instance, where male children are taken to be above the female children, and then eventually later you now have a male child, you can actually change that next of kin and now put the male child 60%, and now put the female child 40%, even if the female is the senior. That is where that is still being practiced.
Is that like a standard?
No, it's not a standard, but some people practice where they say the male child is over and above the female child. I know you are a woman, you will not.
Yes, of course, I will not.
or okay, let me balance it.
Okay.
Where they now say 50-50.
50, and I'm the senior.
You are the senior, you take 50. Then the man take 50. You, the female, you take 50. The man makes it like that. Remember that at the point you filled that form, it was only your name that was in that form as next of kin.
Yes.
Now, under ordinary situation and circumstances, he could not go back to change it. By the time the male child is born, he wouldn't have had the authority to change it. But because that next of kin form that was filled is what is part of what we call an ambulatory will, he now has the right to go and change it, and now he can now go and change it and put 50% for Joy Dambo and 50% for Roland Osim. You understand? So it's a kind of an ambulatory. That next of kin details is a kind of an ambulatory will. It's a testamentary document that speaks from death of the maker. That is by the time the man dies, and then Champion Breweries or Federal Minister of Health wants to pay the terminal benefits of that man. It is the next of kin that is to be paid. The money is supposed to be paid to. Now let us look at the circumstance where that next of kin is below the age of 18 years.
Okay.
That next of kin is below the age of 18 years. What happens? It is the guardian ad litem now that will go and process those documents and have the money paid into his or her account. Don't forget that that child cannot even open an account. It is the age of 18 in Nigeria that you can open an account.
Yes.
That is the age when you are seeing that you have started becoming an adult. So at that age, when you are below that age, it is still that guardian ad litem that will go assist you in running all those processing all those papers for that money to be paid. And for that guardian ad litem to be able to succeed, he himself has to go on air or in a newspaper and then publish in a newspaper that he is the appointed guardian ad litem of James Okun Etam.
Is it like very compulsory to do that?
Yes, otherwise you may not be seen as the guardian ad litem. Remember, you are the guardian ad litem, but there is no document written to you that you are the guardian ad litem. It is in circumstances like that that you now go to the newspaper and then make a publication in a national daily telling the entire world that you are guardian ad litem. What it does is that that newspaper will circulate within Nigeria, the federation, for 21 days. And if somebody else does not come out to say, look, that Kenneth is lying, I am actually the guardian ad litem of Okonetam, you understand, it becomes an estoppel against anybody that will come up subsequently after the papers have been processed. Remember, by the time you do that, they will gather everything, the next of kin details, who is a minor, the guardian ad litem details, the newspaper publication, they will gather everything, and then they start processing the paper, sending it to the pension fund administrators and to the bank. In fact, it is that newspaper publication that gives you entitlement to go to the court to do what we call the letters of administration. So that is how you are the guardian ad litem. You bring all this in, you go and do letters of administration, you send it to the bank of the man where the father of the child died. The child cannot access the bank account, so you are the one that will send the letters of administration to that bank. You are the one that will send to the office, that you are the one that will send to the pension fund people, and together they will now process these papers and have the money paid into your account. So from that day, you are owing that child, if they pay 700,000 naira or 1 million naira, you are owing that child 1 million naira to be refunded to him at the age of 18.
Oh, really?
Yes.
Are they really sincere enough to give
unless you are keeping account of what you did, that the child will acknowledge you did that. For instance, if the child was going to school, some people can be very, very dubious. He can now say, okay, this child is going to school, it is from this 1 million naira who sponsor him in school. So it's better for you to have a statement of account, so that when you pay the fees, you record how much you paid, and then you keep the balance. You know you pay 20,000, you keep the balance, it's now remaining 980. You pay 20,000 next time, so that by the time that child is 18, you now bring it down that, okay, as at this time you are 18, this is what I spent on you since I collected your father's terminal benefit, this is the balance. You are actually owing him that balance to be paid to him at that age of majority. You are actually owing him because you were a guardian ad litem, and everything you did was accountable for.
Okay.
Yes.
All right.
It was a kind of a trust, what we call a trust, equitable trust. It was a kind of a trust between you and that child.
Okay.
Yes. So that is guardian ad litem. Then there is the wardship. You can actually be the child's ward. You understand?
Okay.
You can actually be the child's ward. There is the wardship. There is the guardian ad litem. I had already said that if the child, somebody had offended the child, and you want to sue, you sue as next friend. In that case, your nomenclature changes to that of a next friend. You sue as anybody. If somebody is taking that child to court for having committed a thought or a wrong, you are now the guardian ad litem. You defend as guardian ad litem.
Okay.
So those are the operative parts that are very important for people, the wards, foster homes, adopted parents to get to know that that is what, apart from the fundamental right of the child, we are now talking about sexual abuse. Those are the operative parts. Sexual abuse. In fact, there is a prison sentence attached if they find out that you have committed incest. Because if you take an adopted child and have sexual intercourse with him or her, then that is incest, because it's taken that you are the father of that child, or you are the mother of that child. So that is incest, sexual abuse, sexual molestation, abandonment. You cannot pick up a child for fostering, you cannot pick up a child for adoption and then abandon. If at the end of the day something comes up that that child has to leave your home, you take that person back to the court. And then inform the court the circumstances under which you want to return the child to the foster home. Remember, the government has a foster home, and in most cases you go to that foster home to adopt that child. So if there are circumstances, for instance, some people will say the child is a witch. You understand? And then it is even a criminal act for you to say the child is a witch. Yes, no, it's criminal. Yes, it's criminal, because they say that witchcraft is spiritual. It's metaphysical. So how do you prove that the child is a witch? So if you either like go to the court to now say, I want to return this child because this child is a witch, then you have committed a criminal offense for which you go to prison for 7 years. If once you make that statement and it is recorded against you, Madam, talk this thing where you talk again, you mention that this child is a witch. Madam, do you know what you are saying? Yes. The next thing is that you see a criminal charge being slammed on you, that you have desecrated that child for calling him or her a witch. And then you yourself, before the child gets back to the foster home, you are already in prison and you stay there for 7 years. No, you, not Joy Dambo.
Oh, of course.
So those are the operative parts that people have to know. And then where there is disagreement over paternity, when there is disagreement over paternity of the child, just like it happened in that case study that we read, then the law under section 63 of the Child Rights Act and Child Rights Law says that section 64 in case of the Child Rights Law, it says take the child for paternity test. Okay. What they call DOC. What we actually call DNA test is in the full sentence for it is DOC ribonucleic acid test. Okay. DOC ribonucleic acid test. That is DNA, that's the full meaning. So you take the child for a full, like in that case, you see now, the man will have taken an oath that is not the father. In fact, if it is in African setting, the man will have swallowed juju that is not the father. But the DNA test clearly and simply showed that, okay, you are the father of this child. They did a test there, it showed you are the father. They take him to another lab because it is the DNA samples of his body that are taken. They match it with the DNA samples of the child. And if that man is a father, it will be the same. Okay. So the law says when there is disagreement, and then the law also talks about guardianship. Okay. Guardianship, custody. So if there is disagreement between the father, in case the father and the mother were together until they broke up during the pregnancy of the child, or when the child so soon thereafter, after the child was born, the law is very clear that the father has to support the mother with finances, which you call maintenance. It has to be given, they have to agree. If they don't agree on how much they will be giving the mother every month for the maintenance of the child, then the court will impose an amount. So it is even better for the father to agree, or the mother, in the case that the child is in the custody of the father, to agree, I will contribute 20,000 at the end of the month. Where he fails, and then the welfare, that case normally begins at the welfare. The various state governments have a Department of Social Welfare. So it normally begins at the Department of Social Welfare. When they leave the Department of the Social Welfare, it will be taken to the court. They take it to Ministry of Justice. The welfare people will write a brief and send that matter to Ministry of Justice, either State Ministry of Justice or Federal Ministry of Justice, depending on where it was begun. It was begun at the Federal Welfare, then Federal Ministry of Justice. It was begun at the State Welfare, Social Welfare Department, then State Ministry of Justice. Then the State Ministry of Justice will now take the matter to a family court. There is a provision for a family court in all states of the Federation.
Okay.
By the Child Rights Act. Every court should have the magistrate court should have a family court, the high court should have a family court.
Okay.
They have days of sitting. So the judge that is actually sitting, there is always appointed one judge that is a family judge. So that the duty of the family judge is to sit down on all these issues that affect the child.
Okay.
So by the time they bring the child, the mother comes, they say you don't give feeding money. When Ministry of Justice get the brief, they will now institute an action, and then they will serve you with the document, with a rider, that if you fail to come, then you'll be sent to prison.
Okay.
That is always the rider.
All right.
Yeah, so by the time you now go to that court, the court will now ask you, how much can you provide for the welfare of this child per month? If at the end of the day you agree 30,000 naira, then that fact is recorded by that judge, and then an order is made, and then that order is served on you.
Okay.
And for God's sake, any day that woman gets back to that court and say, this month you have not paid the child support, it's either you hurriedly pay the child support or you go to prison. That is the law. But now most mothers, they now realize that by the time the man goes to the prison, they have lost it all. Because the man will not stay in the prison and be paying the money again.
Yeah.
So they will now agree, they will now shift grounds and say, okay, if he couldn't pay this month, okay, next month pay 2 months. So by and large, I think those are the most operative parts of the child maintenance: the fostering, the adoption, the wardship, the guardian ad litemship, and then the best interest of the child is what the court considers in every affair or every case that concerns the child. Don't forget that social welfare department, let me end here. Don't forget that social welfare department, they have assessors, they have child development officers, and they have supervisors.
Okay.
That is the staff, that is people with the ranking, designation. So you can be a senior child development officer, principal child development officer, assistant chief child development officer, assistant director child development. You understanding me? So it is a ranking in the service.
Under which category?
Under the social welfare department.
Department.
So now these people will know you to your address.
Okay.
So when a matter comes up and then the welfare of that child is in dispute, they will send these child development officers, the supervisors, and the child assessors. They will come to your house and know where you are living.
Are they like organization on their own? Or
no, it's under the federal government, under the federal or state government, under the Ministry of Women Affairs and Social Welfare. That is where they operate. So they can actually knock on your door at any point in time to see how you are relating with that child, at home.
All right.
Yes.
Thank you very much. Thank you very much, Barrister Kenneth. I think you've been talking, very elaborative on each of the parts and the right, of course, the operative parts of the Child's Rights Act. I think you've been able to brush down everything we need to know under that category. Yes, I will also give the house to Barrister Roland Usim. I hope you also talk for 1 hour. That was a joke. Anyways, okay, so yeah, before we go into what will is all about, because you also mentioned will in your discussion, I would like to at least want you to attend to this question that is coming from Sister Gladys. I think is part of one of the things you narrated, but I don't know if it's correct.
Okay.
You can as well throw more light to that. She says, please throw more light on how the judiciary in Nigeria handle a situation where children are involved in a failed marriage. What are the modalities for co-parenting and so on?
That is what we have been talking about.
Exactly.
But then the question, let's still answer her. Let's answer her.
Yeah, I would like Barrister Osim to answer that.
Let him come.
No, let me answer. Let me answer. But
Okay.
I have my own.
Okay, that's so rude.
Yes.
Okay, okay, so it was shared, yeah?
Yeah, so
all right.
when it comes to a failed marriage, remember there was a marriage.
Yes.
That I'm happy she said a failed marriage. That means that maybe this man and this woman had a child during lawful wedlock. And now they have gone for divorce. Let's call failed marriage divorce. It can actually be divorce for her own edification.
Yes.
So that she knows what happens. She can actually be divorce. It can actually be separation. In most cases, what we call divorce is just a separation.
Yeah.
The man is not living with the woman, but they are still married. She has not changed her name from that of the man. They are still living with the same name. If it is Dambo, the woman is still called, answering Michael Dambo, and the woman is still answering Christiana Dambo. You understand?
Yeah.
So in that case, there is no divorce. But in the case where they now pull it through so that at the end of the day, the woman doesn't answer my name again. She now, if her father's name was Etam, she now goes back to answer Etam. In that one, that is a different case. In that one, there has been a decree nisi, what we call a decree nisi by the court, and then there is what we call a decree absolute. Once you get a decree nisi,
drop down the
yes, I'm coming. Yes.
Okay.
When you get a decree nisi, it actually means 28 days to the dissolution of the marriage.
Okay.
Decree nisi actually means 28 days to the solution of the marriage. Okay. So if both of you don't come back to that court within that 28 days to say, my judge, I beg, we were just quarreling, we don't want to be separated, we still love each other. Once it is that 28 days, that decree nisi, which was a kind of a temporary separation, becomes absolute. So when that decree absolute comes in for that, there is a divorce. Now, whenever a divorce occurs, two things become paramount.
Okay.
One of them is custody of the children, the other is maintenance. Custody and maintenance. And we have discussed it here. That is when the court will now impose based on the means of the man. For instance, if the man is working in mobile and is earning 500,000, the court can sit down there and then impose 100,000 naira on the man.
Okay, sorry. Who takes the child? Is it the one who earns more, or is the one because when you made mention?
No, there are rules. I'm coming. That's why I said let me answer.
Okay.
There are rules gathering who takes custody of the child. For instance, if it's a female child, the law will always lean in favor of the mother taking care of that, taking custody of that child.
Okay.
The law will not allow the father. In fact, if the law realizes that the father is the person keeping custody of the child, and there is any breach in care, that man is going to prison. So if you are a normal man, you realize that this is your daughter, you understand, or your adopted child, you understand, and you may be tempted. Let me use that language. It's better to allow the mother, whether it was adopted mother, whether it's the real mother, to keep the female child.
Okay.
So when it comes to female child, there is special consideration. So let's assume that those two parents had 3 female children. It is the mother that will take the 3 of them.
Wow.
Now what happens is that if the man had a home, if the man had a house, and he doesn't want that woman to stay in that house after the dissolution of that marriage, he himself has to rent an apartment for the mother
and the children.
And be paying that money I mentioned, depending on his means. If he's a federal civil servant and is on salary grade level 12, and you know that the man is earning 170,000, 30,000 naira or 40,000 naira can be deducted his formal salary at source and paid to the wife or to the mother of the children, depending if it is a separation or or if it is a jactitation of marriage, or if it is a divorce. So the woman keeps collecting that money until when they make peace. If at the end of the day there is peace between them, and that woman is back living under the roof of that man, that is when the payment of that money stops.
Okay.
Or what we call alimony. In fact, before the judgment is even delivered, we call it alimony pendentalite.
Okay.
Alimony, that is the money that you pay pending the end of the suit.
Okay.
Pending the end of the suit, alimony pendentalite. And then when the judgment has been delivered, it becomes maintenance. You keep paying maintenance of those children. You cease to pay the maintenance of those children when all of them become the age of 18.
Okay.
Yes, when all of them become the age of 18, you don't pay again, because at that time they are no longer children. They are taken to be able to take care of themselves. So whatever you are contributing,
they are into,
yes, whatever you are now contributing is outside the coffers of the government. I'm talking about the one the government will impose and ensure that you continue paying and contributing. You have become absolved of that liability when they become the age of 18.
All right, thank you.
Now,
so much.
if the child is a male, and then he's staying with the father, decided he wants to stay with his father, and then both of you are divorced, then it will be the decision of the mother that, look, this is what I will be contributing. Okay, I will be buying clothes to go and give to my child. I will be buying shoe. You understand?
Yeah.
I will assist the father to pay. This is the kind of child school I want my child to attend. If he cannot pay 120,000, let him pay 80. I will be paying 40.
Okay.
All this can be documented and will be documented, and then taken into judgment. What we call consent judgment. There's what we call consent judgment. If me and Barrister Osim, we have a problem, and then both of us are sitting before you, you are the judge, and then both of us agree on something, so okay, let this telephone not be here again, let it be staying here, and then you record that fact, that is what both of us agreed. That is a consent judgment.
Okay.
So that is how.
Yes, thank you so much, Barrister Kenneth. Yes, I would like us to manage our time because we're already running out of time. Yes, so Barrister Osim, I will now give the floor to you to talk about will. What is will?
Thank you so much.
Yeah.
A will is an intention or wish of a person to be carried out after his death. Now, when we talk of intention, in a will, before a will will be valid, even if it is the written type or the other types,
what are the other types?
I'm coming. I'm going to list them.
Okay.
There must be an intention. Okay. Once there is an intention, then that will is valid.
Okay.
Now, the formal will was introduced to Nigeria by Wills Act of 1837, and then subsequently it was amended to become Wills Law of various states, because every state, as we are in Nigeria, they have their wills law. Now, we have features of a will. In every will, or before a will will be authentic, or a formal will will be authentic, there must be features to it. Now, we have one of the features is a will must be testamentary. That is to say, that will can only speak after the death of a testator. And who is a testator? A testator is a maker of a will. When you write a will, then you are now called a testator.
Okay.
And then that will can only speak when you are no more. That is to say, you cannot make a will and that will start operating while you are still alive. So it must operate when you are no more alive.
Yeah.
So that is why it is testamentary. Then also the second feature of a will is that it is ambulatory, from what my senior colleague mentioned already.
Yeah, meaning
this ambulatory means it can be changed, it can be amended, it can even be revoked. You can make a will now. There are some certain people you have, put in the will that they are going to be the beneficiaries.
Yes.
Maybe as time goes on, there are one or two things that happens and you want to change, you can still go and make changes. So that makes it to be ambulatory. Then the third feature is that a formal will must be written. Now, that will must be written by the testator, written, signed by the testator, and also witnessed by at least two persons. When you do the writing, you must, as you are signing, you sign in presence of two persons to attest to it, or you acknowledge in their presence, and they equally have to jointly sign. Then the other aspect also is that the will, another feature of the will is that will must describe the properties that you are disposing. Because you cannot just write without listing properties. So that's one of the features also. Then the last feature is that the will must also state the beneficiaries, those who are going to benefit in that will.
Okay.
Then when we move from there, we also move to what are the types of wills. Yes, because there must be types. So now you asked me that earlier on.
Yes.
The types of will, we have the first one is a formal will. This formal will is put into writing. The testator must write the will, and then this will that he has written must be attested to by two witnesses, who will do the same thing at the same time. So if one of them comes down and sign and attest and go, another one comes and attest and go, it's not valid. They must be there together to attest, yes, to witness your signature on it. Or maybe you have already signed, then as they are coming, you now acknowledge to let them know that I am the one who signed, who made this will, and I have signed it. So they will now attest. Then we also have the second will, which is non-cooperative will or customary will. Yes, this one is an oral directive. Yes, somebody can, a testator, or it is before a testator, let me use that word. A testator can dictate, can tell somebody, either a heir to the family, about how his properties will be, disposed after his death.
Verbally.
So, verbally. That one does not need attestation or whatever. It's just to tell witnesses.
Is this not what causes problem in the family?
Yeah, of course. Making of a will is important, but like in the African setting, people are afraid of making wills. If you even tell them to make a will, they will feel you are reminding them of their death, or you want them to die so that you benefit.
Yes.
So now then, the next type of will is what we call mutual and reciprocal will. This one is made by two persons or more. Two people can come together and then decide to say, at the death of, if you are the second person to die, that maybe Mr. A may die before Mr. B. So the Mr. A and Mr. B will now agree that, okay, if Mr. A dies before Mr. B, so Mr. B is going to will this property to Mr. C, who is a third party. You understand now? So if it happens that Mr. B dies before Mr. A, the same thing will happen. So that one is mutual, and this is common among husband and wife. Yes. So then we also have the next will, which is privilege will. In this privilege will, it is done by those in the category of workers who are in actual service, like the soldiers, the mariners or seamen who are at sea, or a crew of commercial airliners. So those people, because they won't have the time to sit down and start writing a will and to wait for people to attestators to come and attest to the will and all that. So because of that, they have that exception to say they can even do it orally. They can either write it without waiting for any formality. So that is why it is called privileged. They have privilege to do that. Then we also have another form of will which is called holographic.
Okay.
This holographic is handwritten. You just write, you can even write it and sign and put it under your bed or anywhere, any day you die, maybe in course of people coming to, sympathize with their family, they now pick it and say, this is a will. That one too is another form. But that one is only applicable to those states that valid them.
Okay.
It's not common. Then the last one we have is the statutory will. This one is made according to the statutory requirement of some certain group of persons.
Okay.
Like for instance, the Armed Forces Act, the Armed Forces Act 2004, which is applicable to only the soldiers. So that can be done.
Okay.
Then also, after talking about the types, we equally talk about the capacity. What is the capacity of making a will?
Okay.
Yes, because it's not everybody that can jump and start writing a will. One, you consider the age capacity.
Okay.
Now the age capacity under Wills Act is 21 years old. You can write a will.
That's writing a will.
But in Nigeria, under the wills laws, it is 18 years. At the age of 18, you can make a will. Then we also talk about mental capacity.
Very important.
Mental capacity here is that you must have a sound mind before you can write a will or you can make a will. Because if, as a madman on the street, you cannot go and write a will and tell people, it will not be valid. So your mind, you must have a sound mind. And this sound mind is at the time of making the will and also executing the will. Executing, that signing. Yes. If after making that will and then you execute and everything is done properly before you become mad, it is still presumed that that will is valid.
Is valid?
Yes, because it was made before your madness.
Okay, so now, yes, because some people might assume that this person that is mad made this will. So what if they wake up to say that, what if this man did not make this will?
Well, they
because
need
the
to
person
prove.
is mad. Because somebody can argue
yes,
that.
no, I'm coming to that.
Okay.
In the presumption is that a will that is made ex facie, rational and logical is made out of sound mind.
Sound mind.
So, but if there's any evidence to show that this will was made when the person was not having sound mind, then that can now displace the presumption.
Okay.
So in this presumption, we have a maxim, a legal maxim that says, omnia priye somoto rite esse acte. Let me come again.
Okay.
Sounds like Bayelsa. You should understand that one. You should understand that one. You're Bayelsa now.
Yeah.
It sounds Bayelsa.
Okay.
So,
Let me come again. It's omnia priye somoto rite
This is a language.
esse
no,
acte.
it's a Latin.
That is to
It's a
say,
Latin word,
that is
yeah.
to say, the meaning of this is that everything presumed to be good is good, is okay. That's to say, when you see that this thing is good, especially why they said ex facie, logical and rational. A will has been prepared. They brought it, the propounder brought the will, you saw it, that everything is being done according to the rules. It is, every man will say, yes, this will is valid.
Yes.
It's done out of sound mind.
Mind.
But if there's an evidence to prove, maybe like what you were trying to ask,
Yes.
somebody who has known this person to be mad for
A very long
even
time.
when he was small, you will now say, no, this person has been mad since. Now this will, how do you think it is done out of sound mind?
Yeah.
So that's where it can now displace that presumption that it is done by when the person was having sound mind. Now, there's also a case of Banks versus Goodfellow, which also stated the lay down the requirement of proving mental capacity or sound mind. That one, the maker of the will should know the implication or should know the act of making a will. You know, when he knows that this thing is writing is not just a letter, it is a will he's making. When the maker has that sound mind to do that, then it is one. Then two, also, the maker of the will should know the nature of the properties he is disposing. Yes. When he knows, that is two. Then the third one is the maker of the will should equally know the beneficiaries whom he is going to dispose these things to. So once it is proven that these things were put into consideration, that means that will was made out of a sound mind. Yes. Then also, when you talk about the sound mind, like I said, it is just at that material time. And then in the will, we also have what are the requirements for making a will.
Okay.
The requirement for making a will. Now, we have the first requirement for making a will, a formal will, is that the will must be written. It must be written. The writing has no prescribed formula. It can be written anyhow, but so long as the intention, your intention of making that will has been displayed. Then two, a will also should be signed by the maker and then attested. So now the signature, after your will, you sign, and then the two witnesses attest in your presence. So once you are able to get that, then you have made a valid will.
Sorry, yeah. When you say they have to attest, so is it that when you're making this will, people must be there?
No, not when you are making, because to make a will, it can even take you.
It's like a private,
It can even take you more than, because you may be doing one by one. You know, by the time you buy a property, you now
pen it down.
You know who you are going to give this one.
Okay.
But when you have concluded everything, it is when you are about signing, that is when you now invite those witnesses. It's not everybody.
It must not be the people you're handing over these properties to, right?
No.
Okay.
I will come to that.
Okay.
Now, you now invite these witnesses who will come and witness your signature, and then they equally sign. Then, now, in a will, once you are a beneficiary, maybe your name, for instance now, Mr. A made a will. And then in this will, he has put, given some properties to Mr. B, Mr. C, Mr. D. Then, in terms of when it is time for witnessing, he now calls Mr. B or Mr. C to come and witness and sign. That the benefit that he was supposed, Mr. B and C were supposed to benefit from that will, they will not benefit again. Why? Because they are beneficiaries, so they are not supposed to know anything concerning the will. Let me give you, there's a life story. There's a will I prepared, I think last year. Now, when I prepared this will, the man, the testator, he wanted me to call the son. I told him, Father, that sir, you need two people who are going to attest to this will. So he now asked me to call one of his sons and then one other person. I said, no, your son's name is already there as a beneficiary. He said, no, he does. There's nothing he does without that his son. I said, no, sir. Once your son's name comes here, that is one of the witnesses, then he has lost that gift. So that was how he now accepted.
Also, if a child comes in and attests, and the child's name is on that will, automatically the child will not have access to those properties.
He will not have, because it
we
assume
that
that he has been influenced.
Okay.
Then when was also there's under a capacity to make a will, we also have what we call undue influence affecting mental capacity. This undue influence, you know, when you are making a will, it should be out of your free will.
Yeah.
Voluntarily, you should make it, not by anybody imposing it on you. So once you are being imposed or influenced by a higher authority or anybody, then that will be vitiated at that part that was influenced. Because once it is observed or is discovered that there was undue influence, it's not going to vitiate the entire will. It's only going to vitiate that part that was influenced.
Okay.
Now also, when you talk about this undue influence, the influence must be very strong. It's not something that maybe your wife tells you, sir, you would have given me something, maybe this house or that, then you put down. That one is not strong enough. Okay. It's something, maybe a kind of threat, a force. That is where it can be accepted as undue influence. Okay. Yes. Then also, when the two witnesses attest to this will, then it will be assumed that or presumed that the will is valid.
Okay.
Let me add to what he has said. The first thing I want to add before I even go into any other thing is that when a man is making a will or a woman is making a will or whoever is making a will, the immediate target is not his private family. The immediate target is not his children and relatives. A man can make a will and dispose of the entire property to charity.
Yes.
He can make a will and dispose of the entire property to friends and neighbors, and not even include his child. Because the way we are talking about it as if
it's limited to
the family. No,
it's given to anybody.
He can give it to anybody.
That is why it is said,
yes,
his wish.
Yes, so he
can
carry the entire land and write Brotherhood of the Cross and Star should be given to the entire of that property, the entire of that building.
Okay.
Or all what he had. And the children are there, 10, 15 children, he didn't give anything. That does not vitiate that will.
Okay.
It doesn't vitiate that will.
Okay.
Then another part of the will, which he was talking about, non-copulatory will, which I wanted to add my voice to, is the deathbed declaration. A deathbed declaration is a kind of a non-copulatory will.
Okay.
Non-copulatory will in the sense that it is oral. The man didn't have a will, but as at the point of death, please, I may not make it tomorrow. Please, that house that is at Wamosha, give it to my son. That my son, Ejike. Give that one to Ejike. That one at Ambo Street, give him to Roland Lucy. That, as he finished doing that and he dies, it is regarded as a deathbed declaration. So, and it is a will.
Now, the people there to witness this particular thing, what if they decided to claim these properties without being sincere? Because I think cases like that can happen.
Yes, that is.
If I am like the only child,
that is why it's good to be written.
That is why it is good to be written. Yes. But then it does not mean that deathbed declaration is not a will. It is a form of a will. But then, like you have the reason why we say that a writing is better than oral is a fact of the fact. If he could pick up a biro and write HEK, the house at Agwamosho, Roland Nusim at Ekaika, no, somebody cannot deny that one. All they can do is to bring that piece of paper, let's see, and they say, okay, this is what the man wrote now. But the other one is subject to. So that is why over the years, the practice has moved from that oral system. The only people that are allowed to make all these oral wills, like he has talked about pilots, he has talked about soldiers, even marriages on the sea. You understand?
Okay.
Like the Titanic. You remember that old lady now?
Titanic,
Dawson.
yes.
Dawson and Mrs. Dawson. You remember that there was no formal wedding?
Yeah.
But that was a declaration on the sea. And then by the time Jack Dawson died, she now became Mrs. Dawson. You understand? So she can coming from that Titanic back to the society, she is a married woman, because the law allows people that are on the sea, people that are on the air, to go into relationships, which they come down to the planet Earth when they are back, and then they follow up with those promises. So if the man made told, in case this ship sank, please, anybody that is alive, let them tell my wife to go and administer that house at Ikorodu.
So it simply means anytime they go on air, they are to make their will.
No, they are not.
No,
It doesn't mean
it's
so.
not just every time.
It's not every time.
It should be your line of duty.
It must be a line of duty.
And that's where you've been working.
And apart from being a line of duty, it must be during a dire moment or dire situation.
Yes.
A situation of no return.
Yes.
Remember what happened to them?
Yeah.
Remember what happened to them at that Titanic? It was a situation of no return. So at that point, the woman could actually now say, oh, I am married to Jack Dawson. Now, supposing Jack Dawson followed her and then escaped to the land, he could actually tell her, Madam, I know they marry you.
Okay.
You get my point?
Yeah.
So it's only a situation of dire circumstances when there is no, when you get to a point of no return.
Okay.
Then another point he has made, which is very important, is that the person must be a compos mentee. A non-compos mentee cannot make a will. A non-compos mentee is a person of unsound mind. A compos mentee is a person of sound mind. So that is the difference.
All right,
so
thank you very much. Yeah.
There's one I wanted to add also about a blind man capacity.
Okay.
Yes, because a blind man can actually make a will.
A will.
Yes, but before that will be accepted or being valid, there must be what we call a blind man jurat.
Okay.
The same with an illiterate person, you know. And this jurat, you have to read the content of the will.
The braille. For the blind man, the braille.
It's the brain.
Yes.
No, braille. For a blind man, it is the braille. They use the braille to read.
You read.
For him to read.
You read, and then you explain to him, interpret, and he appears
To understand.
perfectly to have understood you. Then that is when the will be valid.
Okay.
But
yeah.
he cannot sign. He cannot attest to as a witness.
Okay.
Because he cannot see your signature as to attest.
Okay. Yes. Based on your the requirements you were reading out here, I would like to ask here: can someone who doesn't have properties, because you said at the age of 18, from 18 one can start writing will. So if I get to the age of 18, 20, 20 something and above, and I don't have properties, am I allowed to write any will?
You can only write will when you have what
when you have
give out.
properties.
Like that,
Okay.
That is why I said. That is why I said the when I talk under the futures, there must be a property, that you
A
are
property.
disposing.
Like that tech millionaire now.
Okay.
That impregnated the lady with the used sperm.
Oh.
He's a tech millionaire now. He has properties
Has
to dispose now.
property,
yeah.
Cash at bank, cash at hand.
Okay, so
Yes,
what about will forging?
To forge a will.
Yes, forging of will. I think I don't know how will the law or wherever.
No, let me explain.
Yeah.
Let me understand where you're going.
Forging.
Yes.
So let me help you. Now, in practice, all what Barrister Osima said is the theoretical
Aspect.
part out of the will.
Okay.
In practice, what you do, you appoint at least 4 testators. I mean, 4 representatives.
Representatives.
You appoint at least 4 legal representatives who will be contacted to administer that will. The will is not, you don't just administer it like that. And then after the preparation of the will is sealed with a wax and is taken to the High Court registry. At the probate division of that High Court registry, where we call probate division, where you get letters of administration of the rest. That is where you go and put the will. So if you end up forging the one at my house, you cannot forge the one that was sent to the court. Now, it is the registrar of that court that will read the will. It is the registrar of that high court. They normally fix a day, they call it probate. It is on that day that everybody comes, the family comes to that place. They will now say, go and bring that will of, let me not use Kennedy to Robert, I'm not going to die now. Let go and bring that will of James Akpanudon.
The fears of will.
Let me go and bring the will of that James Akpanudo. It is the registrar of that court, the registrar,
Okay.
that will read that will to
Okay.
the hearing of everybody. When it is taken from proper custody and then opened in the presence, the will would actually be torn in the presence of all the family members.
Beneficiaries. Okay, family members.
Yes, all the
Because
family
at that point
members.
they don't know who is
Yes, who is
beneficiary or not.
beneficiary of all the family members that were there present. And then the legal representatives must sign off. There are some forms that you now have to take to the legal representatives, and they will sign off. It is after they have signed off, and then a date is fixed, that they will now come back to the court, and the registrar of the high court is the one that will read the will. So the opportunity to even forge it is minimal. But let's assume that it is forged.
Now, what about a situation whereby the will was brought up verbally? Because forging can come from there. Now, a situation, you gave example of somebody that is dying, and then maybe there was
That
just
is why
one
the use
person.
of an attorney is better, and then there is a charging clause. That is why the use of an attorney becomes indispensable, and then there's always a charging clause. So that even that solicitor will charge his fees from the estate.
Okay, no, what she is talking about is like a non-cooperative will or customary will, which is not written.
Which is not written, and then the man is dying at the process. Don't you think the man or whoever is lying down there and the witness there can wake up and write something that this man did not say, but because I'm the only one that witnessed what this man was saying at that time, can't the person forge the will there?
That is why the non-cooperative wills and the deathbed declarations can actually be challenged in the court of law, and it can be set aside.
Yes.
For instance, now, let me now, like I have already pointed out, that making a will does not target the children.
Okay.
The will can be made to anybody, even to my concubine. I can make a will to my concubine, supposing I have. You understand? My wife is there, my children are there. Now, supposing I made that will on a deathbed declaration, the one we call deathbed declaration, and then my wife and children now come and attack the will, the law will lean in their favor and set aside that will. Because if the woman now come, who is my concubine, now come and say, I gave her the entire house, they will ask, how could they have given you the entire house when you have wife and children?
Yes.
But if I actually wrote it, and they know this is my signature, and there was a lawyer that prepared it, I had appointed 4 legal representatives, and they all signed, you understand? And then they send it to the probate division of the High Court. By the time they go and read it, there is nothing they can do, because everything, all the formalities have been taken into consideration as at the time I met and said, is that my concubine that I gave my house to? But when it comes to non-cooperative, it can actually be challenged. And then when they challenge it, it is in favor of the remnants, the people that are alive, the survivors. The presumption is always in their favor, unless there is something else, evidence, intrinsic evidence that you have to show that is not the reportable presumption.
Okay, thank you so much. Yes, we are proceeding, but we are running out of time. I don't know what we are going to do, because since we've not gotten to the part of the summary of this discussion, and I don't know, I wouldn't want us to extend it again to another week. So what do we do?
What we do is very simple. Let us go to
conclusion.
Let us go to some of the points you've not touched.
Yes.
If you can actually, what happens when we're talking about legitimation, you can actually change the name of the child. If you adopted the child, you can actually change the name. And the procedure is actually making available a name. You make available a name, you go to the newspaper and make a newspaper cutting of that name.
Okay.
When you make a newspaper cutting of that name, you now send the name together.
Affidavit first.
Right, yes, the affidavit first, sorry. You send the affidavit to the newspaper. The newspaper will use the affidavit and change the name. Any newspaper house that doesn't pick the affidavit can run into trouble. So you now do an affidavit. The man that gave you the name, for instance, your adopted child, you are changing the name to Sim. You now change your Sim. The man that changed the name will now give the name. You take it to a high court, they will do an affidavit.
Okay.
You take the affidavit to a newspaper house, the newspaper house will do the change of name. Now, if that child is in school, if that child is working, if that child is in a form of educational institution or any place where there is a hierarchy of a institutional administration, that change of name will be sent to that institution. Okay. And then once that name is sent to that institution, and that institution changes, for instance, if you are Unical, they now finish the procedure, like you mentioned, the name is in place, the affidavit is in place, they take it to the newspaper publication, you now take it to Unical. Unical Student Affairs Division will act on that application. Once they send it to your faculty and department, that is their change of name, it becomes final. That is the name that you will use. If you also send it to your institution, for instance, you are working in Ministry of Agriculture, they follow that procedure and then send it to Federal Ministry of or State Ministry of Agriculture or First Bank or Zenith Bank or GTB, and the administrative procedure is followed to the point where that name is changed, and then they give you the new name. It follows you for life. Okay. That is the procedure for changing of name. I think that is it. The only thing is that another thing that is that we may want to ask, since it's a religious program, is how were we all adopted, or how did we all become the children of God? I think that is where we should end it. How did we all become the children of God? Okay. We all became the children of God by the death of Jesus Christ on the cross, who died to save us all. Okay. And then after he died and came down from the cross, he now said, all that believe at the mention of the name of Jesus Christ, every knee must bow, and every tongue that must confess, and that all that believe shall be saved, and all that refuse to believe shall be damned. He now got to the point where he said that by virtue of our belief, we can now cry, Abba, Father. So once we get to that point where we say, Abba, Father, we have become children of God. By the time we just get to that point. So it comes by believing. Faith is by believing, and believing is by the word of God. So the word of God, if you go to John Gospel chapter 1, he said, in the beginning was the word, and the word was with God, and the word was God. And that same was in the beginning was with God. Who was that? That was Jesus Christ. Yes. So once we believe in Jesus Christ, who is the word, if you go to Revelation chapter 19 or thereabout, you will see that he will come with a red garment. He will come with a red garment from Bosra, from the tribe of Edom, and that by the time he comes, his name shall be, he will come with a sharp sword, he will come with as a double-edged sword, and that his name shall be called the Word of God. You go, that at least that portion is very clear. In Revelation 19, it shall be called the Word of God. And that is why when I see people who joke with the name of Jesus, I think they have a mental problem. Because if you do not accept Jesus Christ as your Lord and personal Savior, the door, he said, I am the way, the truth, that door that you even want, look at the use of a door to an apartment, to a house. If that door is not open, you cannot come in. So everything you believe about the Father is useless. The thing you believe about the Son is what saves you. You shall know the truth, and that truth shall set you free. Who is the truth? The truth is Jesus Christ. So all those rebels, tell them that they are not going anywhere. The only place they can go is to go back to Jesus Christ and the return Christ, and then accept him as their Lord and personal Savior so that they can be saved.
Thank you. Thank you so much. We are also going into the religion aspect of law. Okay, thank you so much, Barrister Sim. Because of time, I would just like you to throw a word or two because we're already out of time.
We are children of God right from the creation of the world, because when God created the world, he created the first man, Adam. From Adam, we descended up till where we are today. So through that creation, we are all children of God. And the Father, the Holy Father, is here with us to console us, adopt us, foster us, and do all.
Okay. Okay. All right. Thank you so much. I really, really appreciate. Today was, of course, indeed very interesting, educating. If you were watching, this is the Regnum Continuous Legal Education, and today, we treated. It was actually a summary of the topic we discussed, which is legitimacy, legitimation, and wills. And you've heard all the aspects of legitimacy, legitimation and wills as well. All right, I really appreciate all of you that were joining us on our YouTube platform to watch today's program. Till we come again next week or another week after next week, remain blessed for the rest of the day. My name is Joy Dambo, and I also want to give thanks to Barrister Osim and Barrister Kenneth for always being here to educate our audience. Thank you so much. Remain blessed for the rest of the night. Bye.